Hello friends, in the series on the income tax cases, today we will discuss the case of SAHEBRAO DESHMUKH Cooperative Bank Limited versus Assistant Commissioner of Income Tax. This case is reported in 455 ITR at page number 92. The matter has been decided by Bombay High Court and the date of the judgment is 10th February 2023. As all we know, in the assessment proceedings under section 148 read with section 147, the assessing authorities behave in a very bureaucratic manner. They do not provide the relied upon documents to the assessee, and if they provide the relied upon documents to the assessee, then they are in a shape that the assessee has to pick his information from that relied upon documents, and sometimes this information is in such a clumsy manner that it contains the data of near about 100 parties or 200 parties, and the assessee has to choose that from which party the assessee has the transactions. It means all the irrelevant data are being sent to the assessee in spite of sending only the relevant data which is related to the assessee. Apart from that, the assessee has a right to seek the copy of the permission of the approving authority. The assessee has a right to get the opportunity of personal hearing, and for which there should be sufficient time given to the assessee that the assessee can prepare for the personal hearing. In this case, the assessee asked for copy of the approval of the approving authority, which was not provided. Relied upon documents was not provided. Opportunity of personal hearing was not provided. The objections of the assessee were not disposed of in a sensible manner. So on all these issues, the Bombay High Court first of all said that it is the duty of the assessing officer to provide the standard format which is being sent to the approving authority and on which the approving authority puts its endorsement for giving its approval for opening the case under section 147 read with section 148. This is also a document which is to be provided. We have seen in our taxation practice that generally the department feel very cumbersome and do not give this document to the assessee. Apart from that, the Bombay High Court said that whenever the relied upon documents are given to the assessee, then irrelevant portion should be deleted and only the relevant portion which is related to the assessee should be given. When the opportunity of personal hearing is given to the assessee, in that case at least 7 days time should be given to the assessee so that the assessee can prepare for the personal hearing. And whenever the department is going to rely upon judgments of the various appellate authorities, then it is the duty of the assessing officer to provide those judgments and the relevant portion so that the assessee can distinguish its case and comment on those ratios of the judgment. After giving these instructions at the end of the judgment, the Bombay High Court remanded this matter back to the assessing officer and quashed the earlier assessment done. We have seen that in the recent past, the Bombay High Court has given very classical decisions on section 147, 148, which lays down various guidelines to be followed by the department. But in spite of these judgments, we have seen that the department is very rigid in following the guidelines of even the courts. So, in my humble request and with due respect to the Bombay High Court, these type of orders should be quashed and the second opportunity should not be given to the assessing officer for passing the fresh orders. Even when it will be done, then there will be a message for the department that if you will not follow the procedure of law in the first instance, then there will be no opportunity for you in the future. Overall, this judgment is a very good judgment because it gives a lot of rights to the assessee so that the assessee should not be in dark and the assessee can prepare its submissions so that all the documents, when they will be provided to the assessee, only in that case the assessee will be able to give its submissions in a logical manner, in a lawful manner. At the end of this video, once again, I am repeating the name of the case. The name of the case is SAHEBRAO DESHMUKH Cooperative Bank Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 455 ITR at page number 92. The matter has been decided by Bombay High Court and the date of the judgment is 10th February 2023. Thank you, friends.